And according to me, our submission is that this is fatal as far as this. Because otherwise it really amounts to saying, now I'll just flip it around. Supposing they had provided no criteria. Ultimately, that's what it means. If you are not providing a machinery, it is a criteria less citizenship with a date of 1st January 66. Because nobody is required to go through any evaluation process at all. That's exactly as the Chief Justice correctly observed, that probably happened at the inception of the Constitution, where there was a presumption that everybody who was there on or before a particular date is deemed to be the citizen of India. So that's okay there. But is it now okay here is the question for your lordships to consider. That, my lords, that permit system, etc., has been explained to your lordships. So these, my lords, are my submissions as far as 6.2 is concerned. Now I want to go to 6.3, I'm sorry.
6.A3.
Yeah. Now on 6.A3 again, first point, no time limit. I think that's common ground. Now, if no time limit is provided for working out this section, according to us, the section itself is vulnerable, and I have premised this submission on the basis that we suggested a few expressions that the provision remains on the statute book and continues to act as a beacon indefinitely. It's like a magnet which attracts people to Assam with all the consequences as far as illegal migrants are concerned. And therefore, in our respectful submission, this itself, this is a fatal element to it, namely that there is no time limit which is prescribed within which this process is to be completed. It can be done tomorrow as well. That's open-ended, and that's very, very dangerous and wrong and illegal according to us. So this is our next respectful submission. Now, Milord, I'm focusing on another concept. And the concept which I'm now focusing on is person ordinarily resident in Assam.
This is under the 6A3 challenge, right?
Yes, but it's actually, it will span both, correct? Because that same expression is used here. But I'll just make the point. Now, if we go to 6A1, you will find, if you just have a look at 6A1, you will find there's a definition as far as Assam is concerned, detected to be a foreigner, specified territory, deemed to be a person deemed to be of Indian origin, and deemed to have been detected. Your Lordship sees that? The expressions which are defined. Person ordinarily resident in Assam is not defined. Now, this is very, very important for my purposes, because this is really the entire fulcrum on which both the sections and the subsections and the entire scheme operates. And this was my primary grievance, if your Lordship recalls in the opening. This whole business of making it persons ordinarily resident in India and compelling everyone to remain there. Well, that's one aspect. But now let's focus on 6A3. Now, I ask myself, if you have certain statutes like, say, FEMA, Income Tax Act, you have notions of residency defined or linked to the number of days. Maybe 182 days, it may be something more, but you have to have a clear definition. It cannot suffer from this type of vagueness, undefined expression, key core provision of resident in India, ordinarily resident in India, person ordinarily resident in Assam. I'm sorry, what does that mean? Is it 1 week? Is it 5 weeks? Is it 6 months? Is it 5 years? Is it 2 years? No yardstick at all provided. And this, according to us, cuts across both subsections. It leaves it completely vague. And in our respectful submission, if we are right, unconstitutionally vague. You see, the vice of extreme vagueness in a situation for a core concept such as this, what does it leave it? What is the guidance given to a foreigners tribunal or anyone else? What is ordinary? This is a question I ask myself. Now, in this regard, actually in both respects, machinery, absence of machinery, as well as for vagueness, we have some guidance to be obtained from a decision of your lordships. Yes, this, my lords, I'll just give you the citation very quickly. This is a judgment, yes, of a constitution bench. I'll give you the citation. 69-2 SCC 166. Harakchand Ratnachand Banthia versus Union of India. We'll just request the court master to put it up. 69-2 SCC 166. Now, this had to do, and the relevant paragraph I should just indicate is para 21, in the context of renewal of licenses at page 1, I think it may be at page 1, para 21. It begins with, we now come to section 20. Yes. So I'll just place this, Manoj. It spans both issues. And it's self-explanatory when I read the para. We now come to section 27 of the Act, which relates to licensing of dealers. It was stated on behalf of the petitioners that the conditions imposed by subsection 6 of section 27 for the grant or renewal of licenses are uncertain, vague, and unintelligible, and consequently wide and unfettered power was conferred upon the statutory authorities in the matter of grant of renewal of license. In our opinion, the contention is well-founded and must be accepted as correct. Section 27(6)(a) states that in the matter of issue of renewal of license, the administrator shall have regard to the number of dealers existing in the region in which the applicant intends to carry on business as a dealer. But the word region is nowhere defined in the Act. Similarly, sections 27(6)(b) requires the administrator to have regard to the anticipated demand as estimated by him for ornaments in that region. The expression anticipated demand is a vague expression which is not capable of objective assessment and is bound to lead to a great deal of uncertainty. Similarly, the expression suitability of the applicant in 27(6)(e) and public interest in 27(6)(g) do not provide any objective standard or norm of guidance. For these reasons, it must be held that clauses so-and-so impose unreasonable restrictions on the fundamental right of the petitioners to carry on their trade and are constitutionally invalid. It was also contended that there was no reason why the condition for renewal of license should be rigorous as the condition for initial grant of license. The requirement of strict condition for the renewal of license renders the entire future of the business of dealers uncertain and subjects it to caprice and arbitrary will of the administrative authorities. There is justification for this argument, and the requirement of section 26 of the Act imposing the same conditions for the renewal of license as for the initial grant appears to be unreasonable. In our opinion, so-and-so are inextricably bound up with the other clauses in section 27(6) and form part of a single scheme. The result is that clauses so-and-so are not severable and the entire section 27(6) must be held invalid. 27(2)(d) of the Act states that the valid license issued by the administrator may contain such conditions, limitations, and restrictions as the administrator may think fit to impose, and different conditions, limitations, or restrictions may be imposed on different classes of dealers. On the face of it, this subsection confers such wide and vague power upon the administrator that it is difficult to limit its scope. In our opinion, 27(2)(d) of the Act must be struck down as unreasonable restriction on the fundamental right of the petitioners to carry on business. It appears, however, to us that if section 27(2)(d) and 27(6), etc. are invalid, the licensing scheme contemplated in the rest of 27 cannot be worked. It is therefore necessary for Parliament to enact fresh legislation, etc. So this is important in the context of vagueness, which your Lordship... Yes. So this, my Lords, I think, at least we feel that this is persuasive on the point that when you have such key concepts which remain completely undefined and open-ended, we are left guessing as to what is the exact contour or parameter of persons, my Lords, who are resident, shall be ordinarily resident in India, in Assam, I'm sorry, since the dates of entry, etc. So this is too crucial a concept without any parameter, anything laid out. So anyway, I'm done now with this point. Yes. Now this I should, yes, your Lordship may just note it, that this was followed to strike down 66A in, I'll give you the citation, Shreya Singhal versus Union of India. That's of course a two-judge bench, Manoj. 2015, volume 5 SCC, page 1, at paragraphs 55 to 68 and 85, two learned judges. And in Shaira Bano versus Union of India, this aspect is now regarded as a facet of manifest arbitrariness. In Justice Nariman's judgment, 2017, 9 SCC, page 1, paragraph 101. That is, my Lords, at index number 163 of volume 5 before your Lordship. Shaira Bano is there. So now this is one aspect. Now, there's one other one other aspect which I'll just, since we are on this machinery aspect, I'll just indicate. We have the advantage of a constitution bench judgment in state of Madhya Pradesh versus Baldev Prasad. The citation is 61, 1 SCR 970. And from the SCC print, it is paragraphs 8 and 9 that are relevant. Okay, we'll try and get that. It's the paragraph beginning, the section does not provide that. Above this? Yes, just above. Yes, here. The section does not, your lordship has that. Now, I'll just explain this. So this was in the context of the Gunda Act. And the provision was struck down by the High Court, upheld by the Supreme Court, because the definitions were just so completely vague. Now, just two paragraphs. The section does not provide that the district magistrate must first come to a decision that the person against whom he proposes to take action is a Gunda and gives him no guidance or assistance in the said matter. It is true that under Section 4, a Gunda is entitled to have an opportunity to be heard after he is given a copy of the grounds on which the order is proposed to be made against him. But there is no doubt at all, that all the Gunda is entitled to show in response to the notice is to challenge the correctness of the grounds alleged against him. The inquiry does not contemplate an investigation into the question as to whether a person is a Gunda or not. The position, therefore, is that the district magistrate can proceed against a person without being required to come to a formal decision as to whether the said person is a Gunda or not, and in any event, no opportunity is intended to be given to the person to show cause he is not a Gunda. The failure of the section to make a provision in that behalf undoubtedly constitutes a serious infirmity in the scheme. So what we are is trying to draw sustenance in terms of our argument is that providing a machinery for determining and not just issuing a show cause notice to Gunda, you can't, this converse point, namely that, oh, it might be weeded out in a process if and when someone is detected, is not enough. There ought to be, in our respectful submission, I'm sorry.
For those who take the benefit of subsection 3, there is a machinery.